Hello, I'm Magistrate Michael Douglas. You are here because the Department of Child Services has alleged that your child is a child in need of services, which is also referred to as a CHINS. Throughout this video, I will use the word department to refer to the Department of Child Services. The court has reviewed the petition filed by the department and determined that there is probable cause for this filing. The purpose of this video is to advise you of your rights, the nature of the allegations in the CHINS petition, and what the court can offer with regard to placement and services for you and your child. At the hearing that will follow this video, you will have a chance to admit or deny the allegations when you are before the judge. If your child was removed and is currently in the department's custody, the court will determine today whether your child should remain in the department's custody. If the court determines that your child should remain in custody, the court will also determine placement, custody, and care of your child while the case is pending. This is a civil proceeding, not criminal. It concerns the care and custody of your children. The court may appoint a guardian ad litem or a court-appointed special advocate to represent the best interests of your child today or in the future. Because a petition for CHINS has been filed involving your child, you have important rights that I will now explain. You have the right not to make statements that incriminate you and the right to know that an incriminating statement may be used during any court proceedings. You have a right to receive a copy of the petition. The judge will ask you whether you have received a copy. If you need time to read the petition or you need help understanding the petition, the judge will provide you time or the assistance of an interpreter to read the petition. For the department to have custody or other control over your child, the department must prove by a preponderance of the evidence that your child is a child in need of services as alleged in the petition. You have a right to deny that your child is a child in need of services and to have a trial in this matter. A trial in this type of case is called a fact-finding hearing. The fact-finding hearing must be completed not more than 60 days after the filing of the CHINS petition. The fact-finding could be extended an additional 60 days, but only by consent of all parties. At the fact-finding, you have a right to present witnesses or other evidence on your own behalf, to have the court issue subpoenas or orders to compel persons to appear which you wish to testify or to produce other evidence on your behalf, and to cross-examine witnesses that may be called against you. Later, the judge will ask you whether you understood the rights I just explained to you. If you did not understand any of the rights, please be sure to let the judge know. There are important procedural deadlines in your case. These deadlines generally cannot be waived or extended except in very limited circumstances defined by law. This means court hearings and other deadlines must be met on time. If your child is removed from your care, you must understand that there are strict time limits for reunification services. If your child is removed before July 1, 2026, the court cannot order reunification services for more than 15 months. If your child is removed after June 30th, 2026, the court cannot order reunification services for more than 12 months. These time limits start from whichever comes first, your child's removal or the court's dispositional order. Extensions of time to complete services are only allowed in very limited circumstances and require that you have substantially complied with all court orders. Initially, the court can be more flexible in allowing you more time to complete services. However, a subsequent request to extend the time to complete services will require the court to hold an evidentiary hearing and find clear and convincing evidence that continuing services is in your child's best interests. Extensions are initially limited to no more than 90 days, with one additional 90-day extension possible under exceptional circumstances. If your child is found to be a child in need of services, the court can order any combination of the following conditions and services: supervision of the child while the child remains in the child's own home, require that you or your child receive outpatient treatment at a social service agency, a psychological, psychiatric, medical, or educational facility, or from an individual practitioner. Removal of your child from the home and place your child with a suitable relative, family foster home, or other shelter care facility, child caring institution, group home, or secure private facility, which would include authorization to control and discipline your child. Award wardship of your child to any person or shelter care facility. In this situation, the Department of Child Services has responsibility for placement and care of the child. Partial or complete emancipation of your child. Order that family services be provided to you and your family. Restrain any party from direct or indirect contact with the child. Enter a no contact order to control the conduct of any person in relation to the child. And lastly, issue a protective order to remove an alleged perpetrator from the home of the child. You should also be aware that this case could result in the termination of your parental rights at a later date. This would require a separate case to be filed for that purpose alone and a separate trial on that issue. That is not the subject of these proceedings today. While the case is pending, the court may order you to do the following: participate in a program of care, treatment, or rehabilitation for the child. Be financially responsible for any services provided for the child or for yourself unless the court determines you are unable to do so. Obtain assistance in fulfilling your obligations as parent, guardian, or custodian. Provide specific care, treatment, or supervision for the child. And work with any given person or agency to provide care, treatment, and rehabilitation for your child. You may dispute any allegations made at the dispositional or other hearings concerning your participation, and you may dispute any allegations concerning your financial responsibility or the need for your participation in services. Also, if you fail to comply with any of the court's orders, including an order to pay reimbursement or support, you can be held in contempt of court. You also have a right to be represented by an attorney. You may hire your own attorney to represent you, or you may waive or give up your right to counsel if you do so knowingly and voluntarily. If you want to be represented by an attorney but do not feel you can afford to hire one, you may request that the court determine whether an attorney should be appointed to represent you at no initial cost. If the court finds that you do not have sufficient means to hire an attorney, the court may appoint an attorney to represent you in this case. At the hearing in this case, the judge will ask you whether you understand that you have a right to an attorney, whether you intend to hire an attorney, whether you wish the court to consider appointing an attorney for you, or if you do intend to hire an attorney, or you do not wish the court to appoint you an attorney, whether you wish to go forward with the hearing without an attorney. You may be asked today whether you admit or deny the allegations in the petition. You do not have to admit to anything. However, if you do admit to the allegations, you are stating that your child is a child in need of services. You are giving up your right to a trial or a fact-finding hearing, and judgment will be entered that your child is a child in need of services. In addition to yourself, DCS, and your child's guardian, ad litem, or court-appointed special advocate, the individuals providing care for your child have the right to attend all hearings in your case. This includes foster parents and kinship caregivers who are currently caring for your child. Furthermore, if your child receives services from a licensed child placing agency, that agency, like the other caregivers, also has the right to attend all hearings in your case, including any termination of parental rights hearings that may be filed in the future. During the hearing that will occur after this video, the court will set some important dates for the trial or for a hearing to determine placement and services for you and your child. If you believe you or your child may have Native American heritage or are a member of or eligible for membership in a Native American tribe or Alaska Native village, please notify the judge when you appear in court. The court will also proceed to determine placement, care, and custody of the child, even if the initial hearing is continued to allow you time to hire or be appointed an attorney. The court may also make interim orders concerning custody, physical or mental examinations, or other evaluations, and a finding as to legal settlement for education purposes. The court will ask you and the department for recommendations about the placement and care of your child. The court may also ask for other recommendations about your child. In addition, the department may conduct criminal background checks on you and other members of your household. The results of those checks will be shared with the court to help determine whether it is safe for your child to return home. If the court orders your child removed or continues to be removed, the court will also discuss whether you will be afforded parenting time with your child. If the court orders parenting time with your child, the court may place conditions on that parenting time. For example, the court may order that your parenting time be supervised by someone or that the parenting time occur at a specific place. As a final reminder, time limits in this case are strict and generally cannot be extended. It is important that you comply with all court orders promptly and participate fully in all required services. You will soon go before a judge. If you have questions or if there were portions of this video you did not understand, please let the judge know. If you have an attorney, be sure to ask your attorney any questions you may have.